Ready? Start. Running through the twin acts, namely the Registration Act and the Stamp Act, we could not at any stage reconcile ourselves to the idea sponsored by the Appellants Council that there is an element of commercialism involved in the whole process of registration of instruments or payment of stamp duty, and that the executant of an instrument at the time of its presentation for registration becomes a consumer entitled to service within the ambit of Consumer Protection Act. The reasons are many. The Registration Act as also the Stamp Act are meant primarily to augment the state revenue by prescribing the stamp duty on various categories of instruments or documents and the procedure for collection of stamp duty through distress or other means, including criminal prosecution, as non-payment of stamp duty has been constituted as an offence. Payment of registration fee or registration charges, including charges for issuing certified copies of the registered documents or fee for the inspection of various registers or documents kept in the registrar's or sub-registrar's office, etc., constitute another component of state revenue. In this situation, therefore, the person who presents a document for registration and pays the stamp duty on it or the registration fee does not become a consumer, nor do the officers appointed to implement the provisions of the two acts render any service within the meaning of Consumer Protection Act. They only perform their statutory duties, some of which, as earlier indicated, and are judicial or at least quasi-judicial in nature, to raise and collect the state revenue, which is a part of the sovereign power of the state. We have already indicated above that under the Registration Act as also under the Stamp Act, the officers, apart from performing administrative duties, also at times perform quasi-judicial functions. The courts are also involved at some stage in the matter of determination of stamp duty. The courts and the officers are thus component of one and the same set up under these acts. The presiding officers of the courts are protected under the Judicial Officers Protection Act 1850, read with the Judges Protection Act 1985. But so far as the officers are concerned, the position is a little different. The observations of this court extracted above, on which strong reliance has been placed by the Learned Counsel for the Appellant, are undoubtedly true, and we also reiterate that a government officer may be held liable in tort if in the discharge of his official administrative duties he acts maliciously or with oblique motive or malafide, but the position in the instant case is different in many vital respects. These provisions were not noticed by this court in Lucknow Development Authority's case, obviously because this aspect of the matter was not involved therein. In the instant case, neither the appellant pleaded nor has the district of the state forum recorded any finding that the refusal of the registering officer or the inaction of the collector of stamps was malicious, motivated or malafide. We need not therefore further delve into the matter, since the collector has to take a decision with regard to the nature of the instrument as as also with regard to the amount of stamp duty payable on the instrument. It is implicit that he has to act in accordance with the principles of natural justice and given an opportunity to the person liable under law to pay the stamp duty to enable him to show that the instrument was either not chargeable with any stamp duty or that it was properly and duly stamped. He may also in the process show or indicate that the penalty was not liable to be imposed upon him. The decision of the collector is not final as it provided by section 45 of the Act that the Chief Controlling Revenue Authority may, upon an application made in writing within 3 months of the order of the collector, refund the amount if it is less of the amount which was legally chargeable has been charged and paid under section 40 of the Act. The exercise of the power by the collector is always subject to the control of the Chief Controlling Revenue Authority under section 56 of the Act. The Chief Controlling Revenue Authority may also refer a case to the High Court for its opinion as provided by section 57 of the Act. The procedure indicated in this section contemplates that the collector shall form an opinion as to the chargeability of the instrument with stamp duty and the amount of duty payable on that instrument, and thereafter he shall require the payment of the proper duty or the amount required to make up the said duty together with a penalty which will be either 5 rupees or an amount not exceeding 10 times the amount of the proper duty or the deficient portion thereof. Under section 33 of the Stamp Act, power to impound a document or instrument which is not duly stamped is also available to the courts, including a High Court. Stop.